Hello and welcome to the new series of Drishti IAS. I am Pooja. Today we are going to discuss the NIA raids which were conducted at places where Popular Front of India was functioning, as well as the banning of the Popular Front of India along with its associate agencies by the central government. Very importantly, it has been in the news for quite some time. You have to understand that we need to know from the perspective of prelims as well as GS mains paper 2nd and 3rd about National Investigation Agency, the background of the entire case, about PFI, what is it, and that will be in brief only. What does the government say on what grounds has this agency been banned? What can happen to PFI now? Also, Unlawful Activities Prevention Act of 1967, the challenges, conclusion and the question. Challenges and conclusion will be with respect to UAPA only. Okay. So, as you see that it is a well-made, comprehensively structured segment. It might take longer than 10 minutes, but trust me, if you see this, you won't need to go somewhere else to read about the entire information. Okay. Now, Center has banned Popular Front of India and 8 affiliate agencies for 5 years. And this has been done under Section 35 of the UAPA. Okay. So, there are certain things that we have to understand, that factual information is going to be very important. Popular Front of India, along with Rehab India Foundation, Campus Front of India and other agencies that work under PFI have been banned for the next 5 years. And this is going to be the base of the entire information we are forming over here. Along with this, if we talk about what are the other agencies that have been banned in the past by the government under the UAPA, goes like International Sikh Youth Federation, United Liberation Front of Assam, Deendar Anjuman, Communist Party of India, Marxist, Leninist and LTTE. Moving ahead, let us talk about the National Investigation Agency. National Investigation Agency is a central agency and it has the power to investigate all the offences which affect the sovereignty, security, integrity of India. Also affecting some offence that might affect the friendly relations with foreign countries, offences under the statutory laws which are enacted to implement the international treaties, agreements, conventions and resolutions as demanded by the United Nations. Basically, if we talk about the history of NIA, it came into being after the 26/11 Mumbai terror attacks. So, when passing on the National Investigation Agency Bill, P. Chidambaram said that whilst we make a central agency in order to work against terrorism, we should know that we have to strike a balance between the federalism and also the unitary structure of the country, because public order and police work by the state, under the state, it is in the state list. And earlier it was said that only 8 scheduled laws will be enacted or will be taken care of by the NIA, but recently it has been enlarged, the powers have been enlarged. Okay. And this basically NIA came into being in 2008 by the Act of National Investigation Agency 2008, but it started working only in the year 2009. Alright, moving ahead, let us talk about the other important things. If we talk about the investigation powers, it can investigate into the matters of terror attacks and the possible links with many other crimes, such as smuggling of arms, drugs and fake Indian currency, infiltration from across borders. The powers go from searching to seizing, arresting as well, and prosecuting those involved in such offences. It is headquartered in Delhi, but as it is a pan-India central agency working in order to maintain security and integrity of the country, it has branches in Hyderabad, Guwahati, Kochi, Lucknow, Mumbai, Kolkata, Raipur, Jammu, Chandigarh, Ranchi, Chennai, Imphal, Bengaluru as well as Patna. So remember these facts. Moving ahead, if we talk about the jurisdiction, the powers extend to whole of India and also applies to Indian citizens outside the country. Persons in the service of the government, it doesn't matter where they are posted, but if they are in the service of the government, they can be tried according to NIA. Persons on ships and aircrafts, if they are registered in India, wherever they may be. Person who commit a scheduled offence and that is beyond India against Indian citizen or affecting the interest of India. So here is lying the jurisdiction of the NIA. Moving ahead, if we talk about the Schedule Acts, as I have repeated more so often about the Schedule Acts, there are many acts for which NIA can work, like Explosive Substances Act, Atomic Energy Act, UAPA, Anti-Hijacking Act, Suppression of Unlawful Act against Safety of Civil Aviation, SAARC Convention, Suppression of Unlawful Acts against Safety of Maritime Navigation, and Fixed Platforms on Continental Shelf Act. So please remember all these, because it could be a very tricky question in your prelims regarding what kind of acts does NIA take care of. Weapons of Mass Destruction and their Delivery System Act. Okay. Apart from this, any offense which is related to the Schedule Act, but it is also encompassing the Indian Penal Code, Arms Act, IT Act will also be tried. Only in September 2020, the central government also included Narcotic Drugs and Psychotropic Substances Act that are connected to terror attacks will also be tried by the NIA or investigated by the NIA. Now, how does NIA take a probe? It's not like NIA suddenly wakes up and goes and raids along. It's not like that. There are many factors which are guiding the probe process of NIA. According to Section 6 of the NIA Act of 2008, the state government, when it comes across such a matter which is related to any scheduled act and that is filed as an FIR in any police station of the state, then the state can take cognizance of it and then it can ask the central government to look into the matter. The central government, after assessing the facts and the reports, might direct the agency NIA to take over the case. And here the state government is expected and is mandated to work with the National Investigation Agency. Alright. Sometimes it can also happen that if the case may be the central government by its own, that is suo motu, take the charge of it by saying that this is the case, I want the National Investigation Agency to attend to, and NIA will do so. Moving ahead, let us talk about the other important background of the current situation. The raids which were conducted in the last leg of September, it went by the name of Operation Octopus, okay, and which National Investigation Agency took into its cognizance many cases that were reported against or that were filed against the Popular Front of India, including one recently in April. So it was seen that Karnataka, Uttar Pradesh, these were the kind of states which were saying if we do not ban PFI right now, they will continue to go on with this subversive activities, creating radicalization of a particular community and hurting the integrity, sovereignty of India. Okay, so when this has to be remembered, 5 cases, including the one case which was filed in April, that was the basis of the current raids. Okay, and this was under the Unlawful Activities Prevention Act of 1967. On September 22nd, the raids were conducted and the raids were determined by the court warrant which NIA got a hold of on 20th September 2022. In many states, the NIA conducted the raids. Don't remember all of them, but few are very important, such as Kerala, Karnataka, Tamil Nadu, Uttar Pradesh, Delhi, Assam, Telangana. Don't remember everything, but this is of course one thing that you need to know for the entire story. Now, apart from that, in the second raid, the PFI raids, second one, over 270 rounded up in second swoop in 5 days. So it was a very dramatic step that was taken by the NIA. Moving ahead, let us talk about Popular Front of India. Popular Front of India came into being after the aftermath of the ban on Students' Islamic Movement of India. The current ideology which dictates PFI's mandate is fighting for the rights of minorities, Dalits and marginalized community. But it does not maintain any record of its members. Okay, remember that. So this is the entire thing. It talks about itself as a non-governmental organization with neo-socialist outlook. Moving ahead to the other fact is it is sometimes also, or it is definitely called as a reincarnation of National Development Fund, which was built in Kerala, and that was after the Babri Masjid case. And because of its dissolution only in the year 2006, another important fact that we have to know over here is it is a reincarnation, but this National Development Fund, it got dissolved in 2006, then merger happened and PFI came into existence. Merger of three Muslim groups, namely the NDF, Karnataka Forum of Dignity, and the Manitha Niti Pasarai. Okay, that was in Tamil Nadu. So it's known as a merger only. Moving ahead, if we talk about the organizations which are working under the PFI, which have been banned by the government for the next 5 years: National Women's Front, Campus Front of India, Junior Front, Social Democratic Party of India, Rehab India Foundation, Empower India Foundation, All India Imams Council, National Confederation of Human Rights Organization. This has been taken by the Hindu. Moving ahead, now let's talk about what does the government say with respect to why this particular organization has been banned. First of all, Popular Front of India and its affiliates have been working covertly to increasingly radicalize a particular community and disrupt the tranquility and peace of the country by telling them that they are not secure in the country, they might feel more insecure in the coming future. That has been the premise of one of the many factors which have been the premise of the banning. Leaders of student Islamic movement are still a part of the PFI. Certain leaders of this particular banned group were seen to be a part of the Popular Front of India, and it also had links with the Jamaat ul Mujahideen Bangladesh, which are the proscribed organizations. They also have links with, allegedly they have links with ISIS, and certain PFI cadres worked in Syria, Iraq and Afghanistan as well. Certain of them were either killed or they were arrested. They also do things that disregard the constitution by funding themselves for propagating an ideology which doesn't sit well with the Constitution of India. Involvement in violent cases, murder cases, in states such as Tamil Nadu, Kerala and Karnataka have also led to the ban. And here we talk about the murder of many people in different states of the south, such as Praveen Netaru, Sanjeet Case, V. Ramalingam, Nandu, Abhimanyu, Bibin, and these are the many cases in which PFI affiliates or PFI people have been, involved in. So terrorist attacks. And also if we see, they were going through dubious funding. That means whatever funding they had was not legal or legitimate. They had various accounts which were not, approved or were not sitting well with the financial status of the account holder. So these were the kind of fundings they had got from not only India but abroad. The layered structure, the dubious and covert activities led to their ban. Also, they were creating hub and spoke model for increasing membership and fundraising. As we see that they also used to create hub and spoke model for increasing membership and fundraising. What happened through these many groups which PFI had a hold of? They used to get hold of women, youth society and such models through which they could get more and more funds and also increase their membership for doing subversive activities. Moving ahead, if we talk about what can happen to PFI now. According to Section 10 of the UAPA, the government can criminalize the membership of the banned organization, and if anyone continues to be a part of this particular banned group, then they can be imprisoned up to 2 years and also liable to fine. Section 7 says that prohibit use of funds can also be done. Government can freeze their assets as well as immovable property, and that is of course by the unlawful association, whatever it is. Apart from that, powers have been given to investigation agencies and police to raid and search premises as well. Moving ahead, if we talk about Section 8, then the government can notify any place which in its opinion is used for the purpose of such unlawful association. That could range from building, house, tents, whatever place has been designated, very open-ended. The local DM has to make a list of all the articles in the place, okay? And then the DM can prohibit any person from using the articles that the magistrate deems may be used for the purpose of the unlawful association. That means it will be a no-go zone. whatever the DM designates under the place, quote unquote. Okay, moving ahead, now let's talk about the UAPA. UAPA came into existence in 1967 to effectively prevent the unlawful activities and unlawful association of India in India. And there was a 2004 amendment in which Terrorist Act was added to the list of offences to ban organizations for terrorist activity. Now this redesigning had to do with the now repealed Terrorist and Disruptive Activities Prevention Act of 1987 and POTA of 2002. So whatever was dealt with by these two, after the redesigning, it started to be dealt under UAPA. Under the UAPA, the investigation agency can file a charge sheet in maximum 180 days after the arrest, and duration can be extended further after intimating the court. Remember all this, okay? The center deems an activity as unlawful. If the center deems any activity as unlawful, then it can declare it so by mentioning it in the official gazette. So center here becomes absolutely powerful. But there are also certain issues like the police as well as public law and order, public order basically is in the state list, so it undermines federalism as well. The highest punishments that are available under UAPA is death penalty and life imprisonment. Apart from that, the Unlawful Activities Prevention Amendment Bill of 2019 decided that we should also designate individuals as terrorists, because earlier it was only for organizations, but now individuals as terrorists could also be designated on certain grounds which are provided in the Act itself. Moving ahead, now let's talk about the 2019 amendment. Basically, Section 35 of the UAPA was the main issue here. And once the person is so categorized, if any person has been categorized as a terrorist, then their name will be added to the Schedule 4 of the Act, and that will be a threat on their life and liberty, Article 21. And in the Sajal Avasthi versus Union of India and Association for Protection of Civil Rights versus Union of India, this particular amendment was challenged. It was challenged on the ground that if any individual who may be identified as a terrorist is done so without any judicial scrutiny and is designated as a terrorist even before a trial has begun. Apart from that, it is violative of the Article 14 right to equality, because it should be innocent until proven or unless proven guilty. So this was also threatened. Article 19, freedom of expression has been threatened, and life and liberty as well. There is no governing principle to categorize someone as terrorist, because there is no set criteria on what grounds a person can be designated as a terrorist, and that makes this particular amendment open to abuse. It goes against the right to dissent as well. If any opinion does not sit well with the current government, a person can be designated as a terrorist. This is what the petition is saying in the Supreme Court against the amendment. Now it has of course become an act now. Now there are certain challenges with the overall structure of the UAPA. First, vague definition of terrorist act, because there is no definition, proper definition of terrorist act, and if there is an ambiguity. And again, any open-ended term is open to abuse and also open to litigation. Now, denial of bail, here section 43d5 states the matter, because here it says that if a charge sheet has been filed under any FIR for the terrorist activities, then bail will not be granted, and that is a threat to life and liberty. Bail is a constitutional right. The pendency of trial is a lot, because looking at the judiciary, the pendency in the judiciary right now, the person who might be innocent will continue to, be stranded there as a terrorist, which is not correct. The state is overreaching, as in the sense they are undermining federalism. According to this particular act, NIA as well as the UAPA, the state takes control of the public, what is the meaning of public order. Under that only it can, ask its agency to go and investigate in the matter and designate any organization as terrorist organization. That is against federalism, because it should be dealt with by the state. Now, as it is a classical dilemma where to draw a fine line between the national interest and the interest of the person or an organization which is designated as a terrorist. So first of all, that should be cleared. The judiciary, executive and legislature both should, all the three should work in tandem in order to make a legislature or a law which is well in line with the world practices. Apart from that, it is not very open-ended or ambiguous, so that proper trial can be given. Because right now, the Ministry of Home Affairs will form a tribunal for the PFI to defend their case. But again, they have already been banned because they are allegedly a terrorist organization according to the UAPA. So let's see what happens next. Moving ahead, let us talk about the question. This is a mains-based question. UAPA is criticized by the civil society as antithetical to the constitutional freedom or to dissent and rule of law and fair trial. You have to comment, okay? Don't be biased over here. Present a very proper, informed opinion in this entire question in 250 words. That's it. Thank you so much for watching.